Well, group, needless to say, I was not able to find a court reporter. I apologize. Normally, whenever we have a evidentiary hearing, we try to advise the parties that the associate judges do not have court reporters assigned to the court. And we ask them to provide their own or to make other provisions. I apologize if you didn't get that message. Now, like I said, we've got a couple options. I think I can record this. I normally don't record these, but I think I can record this if the parties would like to make sure we have some kind of record of what the testimony was. Or we can just go with what we've got, introducing the testimony and not having it on record. So what do you have any particular preference? I'd rather try to get it done today. I'm going to be out of town tomorrow, and if we don't get it done this evening, we can do it first thing in the morning, but we'd have to really kind of get through it then if that's the case. Let me add this other party here. So
I think we record it. That would be my recommendation.
okay, Mr. Pitchner, now the challenge for me is to figure out how to do that. Let me see here what my options are. Okay, I see a record button. I'm going to record it on this computer because I don't want to put it up in the cloud because I'm not sure how accessible it is up there. So so I see something that says recording. So hopefully that's going to work. Okay, we're here on, I think we have all the parties here. We're here on cause number DC 22-12240. It's a case to styled Robert Berenbaum versus Gold Dog. And this is a temporary injunction hearing. And Mr. Pitchner, I will let you proceed. First of all, before we do that, why don't we get announcements? Get everyone on the record. Please just state your name and what party you represent in this matter.
Steve Pitzner, and I represent the plaintiffs, Dr. Birnbaum, Robert Birnbaum et al.
This is Gene Blanton, and I represent defendant, counter plaintiff, and third-party plaintiff, Gold Dog 1 LP.
Rebecca Bell Stanton, Your Honor, and I represent the interveners, which are Tyler Grace Auctions and A to Z Specialists.
Okay.
Your Honor, this is Steve Maloof. I am not appearing on behalf of a party. I'm former counsel for Dr. Birnbaum, and Mr. Pitchner thought my knowledge might be of assistance to the court at some point.
All right. And Mr. Alderman.
Mr. Allman's with my office. It's a second computer that I have available on Zoom for the witnesses to testify.
Okay.
So I would start the screen. Your Honor, before we get started, I don't know how counsel wants to address this, but I think we should at least alert you to an update as to where we are before we upset you or we waste some of your time one way or the other. But I think it's fair to say that the parties, including Mr. Pitchner's office and Ms. Bell Stanton's office, have been working together to try to resolve some of the issues. And there was an auction for some of the artwork that took place over the weekend. And so Ms. Stanton's clients ran the auction for some of the artwork that is located inside the leased premise. The parties have agreed that any of those proceeds would be deposited into the registry of the court. And parties are free to fight out who owns what percentage of those proceeds at another date. I just wanted to make you aware, to the extent we have either supplemented or a more stronger term would be violated, the order that you signed last week about don't mess with anything inside the space. We all agreed that it was in the best interest of the parties to try to mitigate some of these damages and fight about the proceeds at another date. And so we did that. The artwork is still located inside the space. It has not been transferred to any winning or successful bidders. I don't know the final terms of the payments. I just wanted to give you an update that you signed an order saying we could or couldn't do some things. And then we went and did some things, trying to think it was in the best interest of our clients.
Okay, just to make sure, Mr. Blanton, I don't have the TRO in front of me right now, but I think the order said that nothing could be removed from the premises. And so just to clarify, nothing has been removed, is that correct?
That is correct. But there is, I believe Ms. Stanton may be able to offer some of this. And again, I'm trying not to get ahead of everybody, but the winning or successful bidders for some of that artwork have an agreement with her client to pick up that artwork sooner rather than later. And so there will be, needs to be an agreement as to how that's done in a timely order, which, as I sit here today, there is nothing before you that says this is what the parties are agreeing to, if that makes sense.
Can I
Well, you know-
supplement, Your Honor?
Go ahead.
Where we are? I'll make it as quick as I can. I'll tell you what I've recently found out.
No, wait, let me address this issue about the auction first, since it's been brought up.
Okay, well, this concerns the artwork.
Okay, go ahead.
Okay, this concerns the artwork. Mr. Maloof was a former attorney for Dr. Dennis Birnbaum, the one that's in the hospital. Anyway, he put me in touch with John Lewis, who handled the prior bankruptcy for Dr. Birnbaum in 2008, 2009. I'm in the process of getting documents, but based on a very quick review of what I've received from John Lewis, and he had to go into his archives, it appears the artwork may be owned by, or it appears to be owned by two entities which came out of the bankruptcy.
Mr.
One is
Pittston,
WO
let me interrupt you 1 second, okay? I want to just address the issue of the auction. I don't want to get into the merits of rules.
Okay, we won't get into the merits of.
And let me say this, Ms. Stan, as long as you've advised the purchasers that they will not be able to take anything out into another ruling from this court, that's fine. I don't care who you've sold it to, but the TRO is pretty explicit that nothing can be resolved or nothing can be taken out of the premises until this issue has been resolved either through a TI or through a merits hearing. So as long as they understand that, I have no problem with the auction.
Thank you, Your Honor. And that is the understanding. We are going to need to propose a modification, an agreed modification, so that we can make those arrangements. Buyers will obviously, that gives them grounds not to pay for the auctioned item if they can't collect it. But we worked quickly and worked well together this weekend, and I imagine we'll be able to get a modification request before the court specific to just those items. But I do want to assure the court nothing has been removed, compliance with the TROs in place. We needed to move forward with the auction to mitigate the damages.
All right, thank you, Ms. Stanton. Now, Mr. Pitzer, you can proceed on your presentation regarding this temporary injunction.
Okay, Your Honor, well, basically, we would like to continue the temporary restraining order, the agreed temporary restraining order, with modifications as per the artwork. And our understanding is that the proceeds will go into the registry of the court. Going further, from what you're telling me, you don't want to hear anything about the title to the artwork at this time. So
I do not. I think you found a temporary restraining order that the court signed. And there were several allegations you made during that particular petition. One was that you needed to get access to the space because there were people who were in dire need of some medical treatment. And that was the initial order that was signed, pending a hearing. We had a subsequent hearing where this issue of items inside the police space may have been subject to some kind of lease agreement and some kind of interest agreement. And that's when we did a subsequent order stating that nothing should be removed until some kind of final hearing, either at the temporary injunction or during the actual trial on the merits. So that's the basis that we're here for today, is to determine if there's information that suggests or evidence that suggests that temporary restraining order should be considered a permanent injunction until your trial is had on the merits. So that's what I want to hear today. If you guys have agreed on how that can happen, that's fine. We may not need to go through a lot of this. It looks like you've come to some kind of agreement. Is that correct, or am I misled here?
No, Your Honor, and I'll let Ms. Stanton explain going further.
Well, I guess, Your Honor, I do have a point about the temporary injunction and whether the scope of it becomes permanent. Allowing access to THOC, Dr. Birnbaum during regular business hours is not a problem for defendant counterplaintiff. And to the extent they need to go in there and either advise patients of where to transfer records, view records of patients, or make arrangements for the proper transfer of any medicine that is stored there currently, certainly we are not standing in the way of that. We won't stand in the way of that. We will make those accommodations. What I would ask is, I don't know that this needs to be a permanent issue until the final trial of this case, depending on what happens with THOC. And all I'm asking is that it may be amended or supplemented upon a motion to the court and a court order. So and let's just be clear about what I'm talking about. If Dr. Birnbaum does pass away and there's nobody left to come back and return to the practice, and there is no argument at that point about the viability of THOC, then I don't think we need to have a continued access until we get a trial a year plus from now. And all I'm asking is that maybe the order for access is supplemented until further order of this court is the extent of my suggestion.
Well, go ahead, Mr. Pissner, go ahead.
I would agree with that, and I would want to suggest, Your Honor, that if Mr. Blanton would be agreeable, would it be possible to get the additional assets that are there, the equipment, the office desks, et cetera, and put it into storage? And that way, theoretically, there would be an empty space that they could release or take, do what they want to take self-help, because if the property gets released, the obligation under the lease, under the Texas law is mitigated to the extent of the payments they get from the new tenant. So I would just ask that the court would allow Dr. Robert Birnbaum, the brother, and or the family to move the rest of the stuff there to a neutral storage space. We could even have it under the control of the auction house if that's agreeable with Ms. Stanton, or we could do some type of agreement that any access to the storage would have to be in cooperation between Dr. Robert Birnbaum and Mr. Blanton, or his client, because that's a pressing issue too, because if we can't get the rest of the stuff out of there, then it just sits there, and I think that's a detriment to Mr. Blanton's client, because he can't go ahead and release the property. And in the interim, Robert has made it very clear that he'll do everything in his effort to help sublease the property. He has one or two potential oncology groups that might be interested in subleasing the property, subject to Mr. Blanton's client's approval. But I think we need to address the issue of the remainder of the property there. From what I understand, there's only desks, furniture, tables, et cetera. So I believe that if the artwork goes out, the only other items is that furniture and fixtures, and I guess there is some exotic fish, and there's 4 or 5 fish tanks, and I guess that would have to go to storage too. And if that stuff gets out, then I think that would help all the parties in mitigating damages. It would certainly help the plaintiff lease company on on the counterclaim, it would help them in mitigating damages by finding a new oncology tenant.
Well, let me say this before you address that, Mr. Blanton. I'm assuming there is a valid lease in place. Is that a good assumption to make?
Yes, Your Honor.
And there are certain provisions in that lease that bind the tenant as well as the landlord. Is that correct?
Yes.
So this hearing is not in any way trying to address those issues. Hopefully not. Hopefully that, and any agreement that you guys can come to and lay this, I'm more than happy to say fine. Anything that you agree to, I will sign, okay? Because you understand what your exposure is and you're willing to negotiate to resolve that. So anything that the lease states, this TR doesn't address that. I mean, we're not designed to address any lease issues unless you want to present that as some kind of evidence to approach your modification. So in response to what you're saying, Mr. Pitzer, that's fine if you and Mr. Blanton can agree on how you're going to do this, and as Ms. Stanton, and you can put that in an order that you're satisfied with, and that can work as the injunction until you have the trial on the merits. I'm fine with that. Mr. Blanton, your response.
Yes, Your Honor, it's more than just the lease. Certainly there are items in the space aside from the artwork that are at issue. There's a large number of sports memorabilia items, and whether or not those have been properly consigned to Ms. Stanton's client and would be subject to some other auction. There is a separate consignment for an auction related to the medical and the office equipment. All of those items, yes, relate to the lease space and whose rights they are in the event of a default. The second agreement, though, that's at issue is the personal guarantee that was signed by Dr. Dennis Birnbaum and what happens to his property under the personal guarantee and the lease. And so now we have an issue of, is it sports memorabilia that belong to him, or, according to Mr. Pitzner, some other potential creditor or interested party from a bankruptcy long ago? And also, are there assets that we have learned with the filing of Mr. Pitzner's documents last week that were wrongfully transferred in trust to the trust of Dr. Birnbaum and for their benefit? And so we say, you can't transfer or sell or assign or do anything with this property unless we agree to it, which we did for the artwork on the auction. But anything else, his personal property under the personal guarantee, is subject to the same terms as the lease. You've got 2.5 years left on your lease, and if you can't show us that you can meet these obligations or that you don't intend to pay, then you can't go off and sell these other assets, and we simply don't know what those are. So this hearing is not just about, one, access to treat patients. It's about, number two, most importantly, what it's always been about is whether or not any of the property that was pledged under the lease, personal guarantee or the lease agreement, can be transferred, sold, conveyed, assigned to somebody else. And that's the relief that we're asking for is, we're the defendant, don't leave us with a guy who's going out of business, clearly THOC has closed up shop, and don't leave us with a personal guarantor who just a few months ago transferred everything to a trust, who then consigned it to some auctioneer to liquidate everything. We need everything to stay in place pending resolution of this. And if we want to move it from one space to another so that we can release the space, certainly an agreement can be worked out and proposed to the court, or they come in and say, Your Honor, Mr. Blanton's misbehaving and not being fair and reasonable, and he's going to be at risk of losing out on his damages. Or I say, hey, we need to do something here. I think that all can be addressed down the road, but I just want to be clear. The TRO isn't just the lease agreement. It's the personal guarantee and any property of Dr. Birnbaum that has been transferred, we think fraudulently, to the trust, and then the auction houses or anybody else who's holding these interests.
Your Honor, may I brief?
Go ahead, Ms. Stanton.
Thank you, Your Honor. Again, our interest is different. That's why we're the interveners. We have the separate auction agreement. Obviously, we are going to cooperatively discuss how to get the art to the buyers. And again, we are going to submit all of those funds to the court and let everybody argue who gets what. My clients have even agreed to postpone collection of their commission on it. The entirety of the seller proceeds will be tendered to the court. So we're not, the auction house is suffering along with everyone else, but we are all working to maintain mitigation of damages as much as possible. Our concern, and I know that I'm not getting into the merits. I know there's allegations that it's fraudulent. I do want to remind the court that this is an individual who is in hospice. I'm not sure when you're talking about transfer of assets and things like that, that we're talking about a huge fraud being done. That being said, I understand the contractual issues that the landlord holds. I understand the contractual issues that my clients hold. We would not be able to store the items at the auction house out of fear that it would get auctioned unless we agreed, like we did last weekend, to parse it out, conduct an auction, submit all the funds to the court, conduct an auction, submit all the funds to the court. My client has agreed to that. Again, there would be details. I do encourage the parties to do that, but for purposes of today's TRO, our focus is on getting the modification needed for the removal of the art that has already been auctioned and a modification to allow access for the next auctions, again, under the same terms and conditions.
Thank you. Mr. Blanton, let me get a little clarification. Are you suggesting that there's property outside the lease space that you're trying to make sure you are protected as far as your security agreement, or you just speak to what's in the lease space?
I am suggesting the first, that there's property outside. The personal guarantee was submitted as part of the lease, and along with that were financial statements and an inventory. And I simply don't know what is in the lease space and what is at home, but those documents committed to the landlord well over $1 million in collateral and assets for the term of this lease. The artwork collection that was auctioned this past weekend, I don't know the final number, but I believe it's about $50,000 is what the proceeds are that the parties are going to deposit into the court and fight about. And so there are still hundreds of thousands of dollars left on this lease, at least 2.5 years, that my client has a secured interest in. And the trust document simply says, I, Dr. Dennis Berenbaum, hereby gift all of my business interests, so that would be THOC's interests, and all of my property to the trust. And so I don't know, are there other things that they're looking to sell right now? Are there things included in the inventory that are at the house and not in the lease space? Are there other assets that are supposed to be used to satisfy my client's secured interest under the lease and the personal guarantee?
Mr. Pitchner, let me see if I can summarize what Mr. Blanton is saying, and correct me if I don't do it as well as you've already done it, Mr. Blanton, but it looks like the issue here is no longer access to a lease space. It appears that Mr. Blanton is saying that your client has guaranteed certain things in the lease, and some of that property is operating as security interest in that is inside the lease space, and some is outside the lease space. And it appears, I did read the counterclaim, Mr. Blanton, and it appears like that property has now been transferred from this individual to a trust, which kind of really exposes Mr. Blanton. Did I accurately kind of state that, Mr. Blanton?
Yes, Your Honor.
So what's your response to that? Because I'm assuming that when you modify this TRO, it is, if I understand it, may kind of expand beyond the lease space, if that's what you're suggesting. Mr. Pitchner, would you respond to that for me, please?
I would respond if, I would respond that if, I think there's two issues here. There's other property in the leased space. I don't think we're prepared to discuss property that might not be in the lease space at this time, but the property that's in the lease space, if we could collectively work another supplemental agreement with Mr. Blanton and Ms. Stanton, I believe she said that they could auction off that other property that might be not personal items of Dr. B, which the family wants to keep, but business assets. They could potentially auction that off and put the money in the registry of the court, although we'd have to work a supplemental Rule 11 agreement or a supplemental agreement to what's already been worked through between the attorneys on the artwork. And I guess we could.
Mr. Maloof, would you like
Want to say
to?
something?
Yeah, Your Honor, I think,
You went
sorry,
on.
I had it on mute. But for the court's information, about 10 years ago, there was a bankruptcy. The sports memorabilia and the artwork was in dispute. There was a bankruptcy court order that awarded some of the artwork and sports memorabilia to what we call T-Hawk, the tenant in this case. And some of the sports memorabilia and artwork was awarded to someone else. And there is a schedule of what was awarded to T-Hawk, the tenant, and what was awarded to others. For example, Dr. Berenbaum or other entities with which he's affiliated. As I understand Mr. Blanton's argument, the artwork and sports memorabilia in the lease space is subject to a security interest. That may be true as to the T-Hawk sports memorabilia and artwork under the lease or Texas law. The real challenge here, or frankly, what I would recommend to the court, is that the parties get together and review the schedules of artwork and sports memorabilia from the bankruptcy court, the distribution approved by the federal court. Then Mr. Blanton and Mr. Pitzner will know what of that artwork and sports memorabilia is under the T-Hawk lease and therefore may be subject to a security interest. And then what of that artwork and sports memorabilia that may be on the premises is not the property of T-Hawk. Sports memorabilia and artwork that is not the property of T-Hawk is subject to a different discussion here. Mr. Blanton refers to a security interest in that that's created by the guarantee. I've seen the guarantee, but I've seen no security interest granted to the landlord by the guarantor, Dr. Berenbaum. I certainly am sympathetic to the landlord's desire to seize everything it can, but the orderly process here may be best if Mr. Blanton and Mr. Pitzner get together. What's T-Hawk's? What is it? As to that which isn't, what are we going to do with it? So maybe they could come back and tell the court, out of 500 pieces, 250 are T-Hawks. They're subject, arguably, to the security interest created by the lease. 250 pieces are not T-Hawks. And then the question is, under what right does the landlord claim to have the right to hold those assets? Because Dr. Berenbaum's assets are being sold. He's in the hospital, and those assets are being sold for fair value. There's no transfer that's taking place. I think they put some of it into a trust, but my understanding is that trust has been selling assets, but those monies are going to pay other creditors of Dr. Berenbaum. And unless the landlord has a perfected security interest in artwork that does not belong to T-Hawk, then it has to stand in line just like every other creditor. And possession is not 9/10 of the law. So before they get too far out ahead of themselves, I would respectfully suggest to Mr. Pitzner and Mr. Blanton that they figure out who owns what, and then they can come back and get guidance from the court on what the disposition should be of those two silos of assets.
Well, thank you very much. That does clarify something for me. Let's agree on what we can agree on. There is a lease, and in the lease, there is a security agreement somewhere embedded in the lease that gives the landlord right to property inside the lease space. Can we all agree on that?
Yes, Your Honor.
And in addition, the plaintiff has personally guaranteed those same interests. Is that correct?
Yes, Your Honor.
And in the lease space, there may be things that the plaintiff owns, and there may be some other things that he does not own.
That's what we're learning, whereas as described by other counsel, yes.
So it would appear to me, and I don't know if you're prepared to do that today, but we have to have some evidence about who owns what. And I don't think you're prepared to do that today. Maybe you can do that on your own in some kind of agreement. But as you know, this TRO will expire in 14 days. We can extend it another 14 days if you'd like, to where you can present that. I think it makes sense to identify which items are subject to the security interest, if that's the objective of the plaintiff. But I think those are the issues that we've got to identify, first of all, is that what's in the space. And I think, Mr. Bland, you brought in an additional area that, are there some other assets that you need to be, that you're exposed to, that you need to protect until you can hear this thing on the merits? So I'm trying to bring all this stuff in together, and I'm trying to narrow it down to what those key points are. Is that pretty much where we are?
Well, I think it's close. The points that you described of finding out what is the universe of assets and what different buckets do they go into, I am certainly not opposed to any of that. Our problem is, I don't know the best way to get that within the next 14 days, given the current circumstances. So if Dr. Dennis Birnbaum's brother, Dr. Robert Birnbaum, has power of attorney and is the next of kin / friend or trustee, I don't even know if he's really the trustee here. I don't know who to deal with. And I think if we were going to extend this current TRO for 14 days, then I would want the actual trustee, whether it is Dr. Robert Birnbaum or somebody else, to provide the schedule of what is it that they have in the trust and what is it that they are paying out of, so that we can all recognize how do we put things into these different buckets and come back to the court and say, please don't let them sell X. We don't have an interest in Y, and we think Z is up for debate, and we'd like to present arguments and witnesses on those issues.
Have you conducted, well, you probably haven't. You haven't conducted any discovery. Mr. Pitchner, what if we do some real expedited discovery? I see Mr. Bland's position, and looks like he's in need of some information. I think the information will help you sort out as well what may be subject to this security agreement. If we were to do some expedited discovery, Mr. Bland, do you think you could get that within a 14-day period?
I mean, I can get the requests out and the issues out to Mr. Pitchner tomorrow. It's really in his court as to how long it would take to respond, and if he's still receiving documents from a previous bankruptcy, or I don't know if he knows the full universe, and so he can certainly provide an answer. I just don't know exactly how confident he's going to feel in that answer. Is my own.
I don't, Your Honor, know that we can answer all these questions within 14 days. I can state we'll try to find out as much as we can find out, but I mean, I was just talking with the bankruptcy attorney, John Lewis, maybe 2 hours before this hearing, and he just sent me a stack of documents, which I haven't had a chance to go through, but it appears with those other assets, it's like Mr. Maloof indicates, some of them may be subject and some of them are probably not. I'll say we'll try to get the information, but I can't guarantee we can get everything within the 14 days. There's one other issue that I think we need to address. There's these exotic fish, and I'm told that they have a value of 5 to 10 grand, but I mean, they need to be treated humanely also. Would Mr. Blanton have any objection to let Robert Birnbaum and the family get the exotic fish out of there? We would agree that for purposes of today, that we understand Mr. Blanton may claim a security interest in the exotic fish, but I think for the humane purposes of the fish, they need to be, the tanks need to be cleaned every 2 or 3 days. They need to be fed daily, and it makes no sense not to let there's, as I understand it, there's 6 fish tanks there.
Who's been doing that so far?
Employees of Dr. Robert Birnbaum.
And
My understanding
what-
is that a vendor came in and treated the fish just this week or at the end of last week. And we have that as one of our visitor logs. And then there are also either family or employees of Dr. Birnbaum that have been coming in to feed the fish. We don't care who comes in to feed the fish or treat the tanks or whatever needs to be done. But I mean, I get that they're live animals, but they're being cared for just as they were up to a month ago. And I don't see why we need to try to parse that out at this time.
Well, I'm gonna leave that up to you guys. If you wanna agree to that, that's fine. But I kinda agree with Mr. Blanton, Mr. Pitchner, that it seems like there's been some care taken of the fish so far, unless you can indicate that that's not been adequate and that the fish are suffering.
That's fine, that's fine.
Okay, fine. Okay, having said all this, where are we today?
Your Honor, I think today we're at the point where we agree to continue providing access during normal business hours for the operation of the medical practice. And that our request is that any of the assets within the property within the lease space remains either in place or subject to an agreement between the 3 parties here. Although it sounds like maybe there's more interested parties in this artwork from the previous bankruptcy, and that the parties will attempt to reconcile those interests and submit an agreed supplemental order on how the artwork can be removed. And if not, take that back up with you, because I took it from counsel's raising his hand in his previous comments that I don't know who all out there has an interest in the artwork, never mind the things that were not auctioned off. So that's 2. And then 3 is any assets outside of the current lease space, there be a schedule provided subject to some discovery requests that I plan to send, and that those assets not be sold or assigned or conveyed to anyone else during the next 2 weeks, so that we can identify what is it that should be subject to further order of this court, and we all reconvene in the next 2 weeks.
Ms. Stanton?
Thank you, Your Honor. Obviously, we'd had an agreement to go ahead and move forward with this auction. And part of that agreement is that we would be able to actually give the auction items to the people that paid for them. If we are now talking about not providing the auction items to the bidders, we've got a whole, not only is it a violation of the earlier agreement, but we have already agreed to put all the proceeds in the registry of the court. Whether someone else has a claim to those proceeds should not affect the agreement that for the auction items that have already happened and people that have already paid. We came to the hearing today with the expectation that everyone was going to agree that we could have delivery of those items contingent upon all the proceeds going to the registry of the court to protect whoever's interest to fight over. I urged the court, and I thought earlier coming in today that we were on the same page with urging the court that for the specific purpose of the items that have already been auctioned, those can be removed from the property, provided to the buyers, and all of the proceeds tendered to the court. That is our interest in a modification of the current TRO. Whatever else the court decides to do in its extension, we do ask that that portion of our agreement be able to move forward.
Mr. Blanton, what's your response to that?
I don't disagree with Ms. Stanton's request. I think that if there are other interested parties out there that we were not informed of, at least on our side at the time of the agreement this past Friday, then that's an issue that will have to be resolved in the court as to the proper percentage or ownership of those interests for the proceeds. I did make an agreement with Ms. Stanton's client that they could move forward with the auction and that we would move forward with claims to ownership of those proceeds. So really, in my mind, it's Mr. Pittner's client that has to make the decision on how this is done, because they're the ones who are going to be subject to additional claims if they're selling art that doesn't belong to them. And how that works, I can't speak for them.
Mr. Maloof.
Go ahead, Steve.
Your Honor, I do think regardless of which entities may or may not own various artwork, that Robert Birnbaum, as I understand it, has the power of attorney. So I don't, and I understand from Mr. Pitzner that Dr. Birnbaum, Robert, was the one who authorized Mr. Pitzner to enter into the agreement with Ms. Bell Stanton and Mr. Blanton. And so I frankly don't see any problem with, I think that, subject to the court's decision, the deal is the deal. And I think Mr. Pitzner was certainly acting within his authority in making the agreement. So I don't think that that's an issue. And the other thing I was going to mention is, Your Honor, I have several copies, or I have copies of some of the pleadings in the bankruptcy court that I downloaded last night. I'll send them to Mr. Blanton. It will help him get oriented. I was not counsel in that case, but it will alert him to some of the issues that he may be dealing with. I don't have a copy of the schedule that listed the artwork distribution that was ordered by the court, but I think Mr. Pitzner may be able to share that. But I will send to Mr. Blanton immediately after the hearing what I was able to download, and it'll save him some time in trying to get oriented.
And Mr. Blanton, I'll send you what I just received an hour ago from Mr. Lewis, John Lewis, the bankruptcy attorney. And it appears to be a bill of sale which sold some of the artwork to the entities WOPM LLC and or Palliative Arts LLC, which are entities, I believe, of Dr. Dennis Birnbaum.
May I also get a copy of all of those, since I
Yes,
don't have
we'll be
any of that
happy to.
information either?
We'll be happy to forward that. I just got that like at 12 o'clock today.
Yeah, I just, didn't want Mr. Blanton to be privileged to go through all those.
No, I'm sorry. I'm sorry, Becky. I apologize.
No problem.
Okay, having heard everyone, I think I understand where we are. I just got one question. Are we going to submit an agreed temporary injunction after you all have met and decided what you want to do? Are we going to extend this TRO another 14 days to iron out some of the pieces and then do one at that time? Where do we go from here?
If I can jump in on that, my preference would be able to get something to the court today, again, at least as to the modification needed on the sold art items.
Okay, I understand your position, Ms. Stanton. I think I do. I think the question is more for Mr. Blanton and Mr. Pitzner. Do we still want to tie up some loose ends and just extend this? Or are we at a position where we can come to some kind of agreement and enter a temporary injunction that will last until we get to the time of the trial?
My feeling is that we extend the TRO for the 14 days and try to have an agreed order, an agreed TI within that 14-day period. That'd be my recommendation.
Now, what that will mean, Ms. Stanton, is that for 14 days you can't take anything out, but hopefully by the time we have the 14th day hearing, you would have resolved it, and it would be at a point where we could know maybe we would have identified who owns what, and to Mr. Bland's satisfaction, and any other issues, and then we'll be able to enter some kind of order that we could all live with until trial.
Can I make, one exception is if Your Honor could allow her to take the artwork out in accordance with the agreement.
I'm not going to allow anybody to do anything. If Mr. Bland wants to agree to that, that's fine. The TRO says that nothing comes out of the lease space, so I'm not going to go against the TRO that we've already entered. If he wants to make some verbal modification to that today, I will accept that. But I'm not going to ask him now to allow her to take anything out unless he's comfortable with that type of agreement.
Your Honor, I think the cleanest way to address the items going forward is that the parties submit either an agreed supplemental TRO order for your review, and that would address Ms. Stanton's issues and the agreements that both my client and Mr. Pissner's client made with hers for the auction and the removal of the artwork, and that we do that to you by noon tomorrow. And if we can't reach an agreement, then you simply sign one of our proposed orders. And,
Okay, now, the issue is that by noon tomorrow, I'm gonna be gone.
oh,
So you guys need to work tonight,
understood.
okay? And submit a modification to the TRO. We'll extend it for 14 days. Have that drafted and to me tonight, so I can look at it and sign it first thing in the morning. And then we'll just reschedule this 14 days, and then at that point, we'll be in a position where we can maybe agree on an injunction.
The other point that I will have in the TRO, just to make sure we're all clear and operating on the same basis, is it's not just removal of other things from the lease space. I want the TRO to apply to the other assets in the trust or whatever the Birnbaum parties have, and that for the next 14 days, they cannot be conveyed, sold, assigned, transferred to anybody else.
Now, I'm tempted to grant that, Mr. Pissner. What's your position?
My understanding is the personal assets from the house, et cetera, have already been sold, so I don't know that, and I believe the proceeds have been deposited in an account for the trust. That's my understanding.
Well, I guess the position that Mr. Blanton is taking is that he wants any of those assets to be frozen, pretty much to be status quo and not transferred.
That's
Obviously,
fine.
if they've already been transferred, that's going to be an issue for the trial court. But his position is that he wants the TRO extended beyond just the assets in the lease space.
Those assets will stay in the bank account, the items that have been sold.
Okay. Well, very good, ladies and gentlemen. You guys have done a good job getting through this. I appreciate your time and your consistency and your persistence. But if you will, I'm going to work late tonight, so I'll extend that same invitation to you guys. See if you can get something to me. It's 2:15. Work hard and see if you can get something to me this evening so I can review it and get it signed, because after about noon tomorrow, I'm going to be gone.
And Your Honor, I have sent to Mr. Blanton and Ms. Bell Stanton those bankruptcy court pleadings that I found last night.
Very good.
And I'm sending this stuff that I got from Mr. Lewis.
Okay, anything further?
Thank you, Your Honor. Enjoy your trip.
Well,
Thank
thank
you,
you
Nice
very
to meet
much,
you, sir.
and I look for your proposed order this evening.
Thank you,
Judge.
Your Honor.
All right, good day.
Good day.